Hey there, awesome folks. This is Mentor Shelley. I am here tonight to talk about this particular case that is going on with UPS, United Parcel Service. Um, I'm concerned about some of the things that I read and how it's being handled. And if you have ever experienced anything like this, or hopefully you're not, it's not going the way that this particular, we're going to get into it. I have some concerns, but I want to at least get started and get into the article, share it with you, have a better understanding of what is being done here, what's the breach, what's the tea, so to speak. All right, so as you're coming in, go ahead and like the video. Drop a one in the comments. If you depending on where you are, drop a one in the video if you heard about this particular situation. If you have not, put a two. In either case, we're gonna get started in about 36. So let's get started, shall we? Come on in and say hello as you're coming in. Hey there, awesome folks. I want you to know that I understand that because of some political decisions and what has happened in the last few weeks, that this topic that I'm exploring can definitely change. In 365 days from now, this may not even be a subject of discussion based on some of the changes that are going to be taking place in Project 2025. I want to start off with that. However, right now, based on the situation that we're dealing with at the very moment, this law still does take precedence. So, what I want to do firstly is get into the pieces of this that is, let's see here, that is relevant to the discussion. First, before we even get to the article, I want to explore the employment law that may or may not be breached here. So in order for us to understand what we're talking about, let's discuss the actual law we have on the books. Now, what I can do is put the link of let me see here. This is EEOC Title V, 1964 Civil Rights Law that may or may not be breached here. Let me put the link in the chat. So you guys you guys don't think I'm just making this up as I go along. This is coming directly from the source. So let's dive in, shall we? Unlawful employment practices. Based on Section 2000E-2 or Section 703, an employer practices. It shall be an unlawful employment practice for an employer to fail to or refuse to hire or to discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such an individual's race, color, religion, sex, or national origin, or limit, segregate, or classify his employees or applicants for employment in any way which could deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individuals' race, color, religion, sex, or national origin. That came directly from the EEOC's website. So I don't want to, I don't want to mince words, and I don't want to say to you that, oh, this breaches this law. I want to make sure that the law is upheld and being observed in its proper and actual official context. Now, let's get into the article, shall we? What we're going to do now, let's see here. We're going to share the particular article that we are talking about tonight. Now, I don't know, have you guys heard anything in regards to this UPS situation? If you have not, we are going to discuss it right now. The Atlanta Black Star is the one that wrote about this. Jill Jordan Cedar published this a couple weeks ago. Well, no, yeah, on November 22nd. The title of it is "Move Faster, Boy." Federal judge slashes $238 million jury award to $39 million for a black UPS driver whose manager barked orders, called him a racist term. Now UPS fights to bring damages to zero. Problematic already in the title. A federal judge has weighed in on a $238 million jury verdict won by a former black United Parcel Service UPS worker in September, ruling that $198 million in punitive damages a jury in Waukesha, Washington awarded was unreasonable and not supported by the evidence in the case. The U.S. District Judge Thomas Wright allowed the jury's award for emotional distress to stand, ordering UPS to pay plaintiff Pahivo Grattan $39.6 million. UPS said it intended to file a motion for a new trial and will seek to overturn emotional distress damages as well. Okay. All right. Grattan sued UPS in 2022 for racial discrimination and wrongful termination, claiming that he was mistreated in the workplace by racist supervisors and then fired in retaliation for filing several complaints between 2018 and 2021 with his union and EEOC, with his union and the EEOC, which we did just go to their website so you guys can see that the information I'm talking to you about, or I'm talking to you about the laws that were breached here, is directly from there. He argued that this termination in 2021 followed a sexual harassment investigation into whether he improperly touched a female's back on a loaded dock was used as a pretext by managers who had previously discriminated against him. In the complaint filed in the U.S. District Court of the Eastern District of Washington, Grattan claimed he was frequently laid off for the day. That's weird. Laid off for the day while Caucasian drivers with less seniority were given routes to drive in violation of union rules. He also said he was given less desirable routes and trucks than other drivers. The Caucasian manager repeatedly referred to him as boy. Now that's disrespectful. Grattan alleged, adding that the manager would yell orders at him saying, "Move faster, boy, let's go. And I don't tell you to talk, boy. Wait a minute." When asked to stop, the manager allegedly said, "I'm from the South. That's how I talk." No, you choose to be an ignorant anyway. The allegations were supported by a staffer at the Foot Locker store who received deliveries Grattan made that day and witnessed how the manager spoke to Grattan. Grattan's complaints to upper management about immediate supervisors' demeaning language, punishing route assignments, and other unfair treatment were not fully investigated and unjustly dismissed, he claimed. Let's stop right there for a moment. Ha ha ha. Hello, hi Clouds in my matcha. How you doing? This is distressing, and I want to make sure that I put this on pause. Number one, under no circumstances in 2024 and beyond should anybody have to deal with or put up with this level of ignorance in the workplace. Just in case you weren't sure, they absolutely did infringe upon his civil rights based on what we've already read and the fact that it wasn't properly investigated leads me to believe that unfortunately the Human Resources Department is not doing their job either. There's some major concerns with a large corporation like this. Why was this not properly investigated and nipped in the butt? And there's no excuse for someone. That's not how you talk in the South. There's a lot of people that live in the South. I work with a lot of people in the South. I live in the South. And nobody speaks that way. He speaks disrespectfully and then wanted to find an excuse to be disrespectful and discriminatory and racially bigoted. That's his excuse. Oh, that's not how you talk. Please, let's get that clear. Okay, so I'm sorry. That rubbed me the wrong way. Anywho, let's get back to the article. In his order issued on November 14th, Judge Rice did not find the investigation by UPS in the alleged sexual harassment that led to Grattan's termination was biased against him by his former employers. Okay, Judge Rice, as Grattan claimed. Rice noted that the neutral third-party investigator at UPS, who had no prior interaction with Yamaka's location where Grattan worked, conducted the inquiry and submitted his report to Carl Layer, the labor manager assigned to adjudicate union grievances. The report included testimony from Linda Hernandez, who said that Grattan had grabbed her right hip while he bent over on the loading dock and said something like, "Hey girl." She said she felt disrespected and harassed and told Grattan, "You touched me inappropriately." That was the extent of it? Okay. Jose Castillo, another employee who allegedly witnessed the incident, testified that he heard plaintiff say something like that "I have got a one-on-one with you" at the time, referred to Hernandez. Grattan insisted that he had tripped on the ramp and had to put his hands on Cruz's back to catch his fall, then apologized. Oh boy. While Grattan's attorneys argued that Lehert was unduly influenced in his investigation by lower levels, racially biased supervisors who had handled Grattan's previous complaints, the judge found that Lehert simply did not believe the plaintiff's version of the events. The court cannot find that based on the evidence presented at the trial, Lehert harbored malicious or reckless indifference to the plaintiff's federally protected rights. Rice said that Grattan was able to tell his side of the story, was accompanied by union representation during the interview, and was able to provide a witness of his choosing. Given the evidence presented at the trial, Rice said, "You talking a lot, Judge, and they're supposed to be presenting to you so you can decide, not for you to have all these opinions." But anyway, excuse me. Given the evidence presented at trial, Judge Rice said that he didn't find the jury's decision related to punitive damages reasonable and therefore vacated the jury's $198 million award. The judge also denied Grattan's claims for front and back wages, writing that his attorneys presented no evidence of wage-related damages at the trial. I remember him specifically saying at the beginning of this article that these managers would suspend him or give him extra days off and give other people his shifts. So he's missing money because of how they treated him. But I digress. Let's keep going. The judge also denied Grattan's claims for front and back wages, writing that his attorneys presented no evidence, I doubt that seriously, of wage related damages at trial, and later filed financial information too late to be considered. So they did present it, you just didn't accept it. Judge Rice? Judge Rice ruled that the plaintiff's claim to be reinstated at UPS was improper since the employee and employer were at odds over reasons for his termination, and also due to the plaintiff's current successful barbecue business. What does that have to do with anything? It has nothing to do with the fact that his rights were infringed upon. I tell you, and this judge already is walking on a whole different level. They need to check him out, and not for the reasons you think. Rice said because UPS had not challenged the jury's verdict for emotional distress, he would order judgment for that 39.6 million. So it went from all the way from 293 million to 39.6 million. The district court correctly ruled that the punitive damages award was improper as a matter of law, said the UPS spokesperson Glenn Zakara in an emailed statement to the Atlanta Star. UPS will file a separate motion to request a new trial and ask the court to overturn the award for emotional distress damages. Attorney Grattan did not immediately respond to Atlanta Star's request for comments to the case. So pretty much what it looks like they want to do is pretty much do their best to make this go away. That's really what this looks like, because not only is this judge saying, oh, well, none of his claims came to the level, although in the beginning of the article it specifically states that he was discriminated against over a period of time. His shifts were being cut, and his shifts were being given to people that were that had less that was there after him, their seniority, and I guess based on the how they operate in UPS, they operate based off of seniority. So his shifts were being given to other people, and pretty much they were messing with his money and calling him. Let me just make sure I go back to this statement right here. The title of this article: Move Faster, Boy. But you don't see a precedence to award him. His rights were not infringed upon. Lord have mercy. This judge, they need to change the judge, and they need to this judge is definitely there's some prejudicial issues with this particular judge. I'm sorry. I'm call a spade a spade. He is full of wahala. I'm sorry. I'm not even going to try to be politically correct on that situation. Based on we already established that they mistreated him based on race, because I'm sure if he was a Caucasian male, they would not be calling him boy. That's a guarantee. That's number one. They would not be calling him boy. Okay? That I know for sure. Now, I do have some questions that I want to pose to you guys, and let me start with this one. Based on what the information that the article provided, did the employer set the precedence for this type of racial discrimination behavior? I believe yes, because they didn't do much to stop that behavior. They terminated him over a perceived sexual discrimination. I'm sorry, sexual discrimination versus the racial discrimination that was taking place over time. So they terminated him based on one thing when he explained it was an accident and he literally slipped and he had a witness to verify that. But you terminated him based on something else. Sounds like you terminated him to punish him because he is actually, saying that you're discriminating against this person racially. So this is a hot, wretched mess. Second question. Just based on what the article has provided. Now, if you have additional information that you can speak to in regards to how UPS operates in general, the next question is, was there adequate action taken by UPS's part to stop or deter this type of discriminatory behavior from occurring going forward with any other employees that look like me? I'm going to absolutely say not, because I don't hear anything about any kind of punitive situations that happen to the manager that's there calling grown men boy. I did not hear, and based on the article, they didn't fully investigate his complaint when he made it on several occasions. Before this came through the court of law, they did not investigate it to the level, which is why he ended up getting awarded that that amount, and then they pretty much are doing everything now to dwindle it down. Well, we'll get to that in a second. Hold on a second now. So based on the article, now I think I've already said this, but I want to make sure that it's clear as crystallized water. The next question is, based on the article, did you find the judge being impartial based on the fact, or partially leaning towards the employer? He wasn't partially leaning towards the employer. He was fully leaning towards the employer. Oh, you can dismiss this too. You can dismiss that. Because there was no proof. They did provide the proof. If there was no proof provided, he never would have gotten that. He would have not been awarded anything if there was not proof disseminated by the the union reps and the attorneys. So miss me with all of that. I think for some strange reason, this particular judge is like in the pocket. Either UPS gave him some shmoney to rule this way, or he is pro-employee. I'm sorry, he's pro-employer to the point of no return. Like, he not trying to hear nothing that the employee has said. He's just saying, oh, this is, nope. Oh, and they didn't provide enough evidence. And oh, when you go ahead and bring this up for a retrial, and there's no evidence. There's no evidence. If there was no evidence, this particular employee would not have won the case. So this judge was prejudicial from the start, based on how he's dealing with it, and how he's literally, based on what the information provided in the article, that he is directing the attorneys that represent UPS, the organization. Let me see here. Next question. Does this judge demonstrate any understanding at all for the employee bringing the racial discriminatory charges against UPS? Nope. Not for 1 second. All this judge want to do is, oh, no, there's no precedence. Make it go away. No, there's no precedence. This, that. No, there's no precedence. And you can get this thrown out too. Like, he straight up said that. And they wrote that in the article. You're supposed to be judging fairly based on the law, and you did not do that. And you're telling UPS to try to dismiss it and not pay this guy anything. Although he won the award for $39-point-something million. Ooh, buddy. This judge is something to be desired, because he's certainly not doing his job. So based on the article, the judge definitely was definitely coaching the UPS attorneys on what to do next. Literally, because He didn't see anything wrong with what was going on, and he claims that there was no proof. I guess if it's not caught on camera, it didn't happen, huh? Ah, boy, I tell you. Now, we could sit here and tongue lash that judge all day long. But guys, going forward, how can the protected status of um, people help themselves in these type of situations? Number one, document everything. If you're able to record, record. Document everything. And as our wonderful illustrious friend of the channel, Cherie from Black Women Making Money says, build your multicultural networks, build your existing network, build your multicultural networks, especially in the areas of business, because you never know when you're going to need them. It is very imperative that you do that because it makes your next move very easy. It makes it a lot easier. Have your career tools ready, folks. Have your resume ready. Have your cover letter ready. Please, if you're enduring anything remotely close to this, let's have a conversation. Book a consultation with me at mentorshelley.com/consultations. Not only will go over what you need to document, but also make sure that you have your career tools ready to go. So when you're having conversations with your network, you have that resume ready to send out to them. Or better yet, they can introduce you to some people that may have some opportunities that you can take advantage of. But if you don't have your career tools ready, such as your resume, your business cards, when you go out there networking in different events live or you're networking in groups online, build your multicultural networks. It's that important. And of course, keep your career tools ready to go. If you stay ready, you don't have to get ready. Okay? Be very purpose driven in your personal economy. If the job is cutting up or anybody remotely want to talk to you sideways like this, you should be able to be in a position with your multicultural networks and having your career tools where you can say, I'm out. Because I'm not going to sit here and take any disrespect from, especially because you're a grown person. Nobody needs to be disrespected like that. And nobody should ever have to deal with that. So what I will say is this. If you know that you may be experiencing anything remotely close to this, it's time to go. It is time to go. You do not need to stay around or remain in any kind of toxic work environment. Your mental health and your health overall, and the level of how you do not want to allow somebody to take you out of your professional space or professional demeanor is vitally important. It's best you walk away in certain situations, because even though there was evidence to support, and even though this guy won the case, you see, you have judges that are literally eager and waiting for ways to completely dismiss this man's rights. At the end of the day, stay ready so you don't have to get ready, guys. And of course, I want to make sure you have what you need. And of course, as you're going out, as we're ending the stream, leave your comment below, have additional questions. But at the end of the day, I want to make sure you have what you need to become a better professional and be able to navigate these situations as smoothly as possible without chin checking somebody. All right, guys, this is Mentor Shelley, wanting to make sure that you become a better version of yourself professionally. This particular article rubbed me the wrong way because this judge isn't doing their job. They're literally allowing this organization to not have any accountability for their leaders' actions. And sometimes that's how it is. But you have to always be ready, because you never know when you'll run into something like this. Stay ready so you don't have to get ready, folks. Y'all have a good one. This is Mentor Shelley. How?